Good evening, ladies and gentlemen, and all my fellow law students. Today we have increased in number. We have we have made a group of three to a group of four. We have with us a term that you can call a founding father of this group or of this YouTube channel at large, Ishwar, who is a very dear fellow of ours and also a student of law in the same university and in the same year. So he was he propounded the idea of having such a thing. So without him, it would not have been possible, or it would not have been justifiable to have this video. So as we have him, we will request some words.
Good evening. This is Ishwar, and as said by Tamogna, I'm also doing law with this gentleman here, and I'm also honored to be a part of this team, and I really look forward to do my best in the forthcoming videos. Thank you.
So, and to move further, we have had a huge number of response. We have in our first video itself had, I think, more than 80 views, which is exceptional, which is very hard, which is really heartwarming and gives us much more impetus to even go forward with videos like this. We have had criticisms on the title of our group, which is now changed into Patzers in law, and the term Patzers is related. Is considered to be a beginner of chess, as chess is one of the forte of the speaker of the day, and then we also had criticisms on the gesticulation and the burst of emotions that I had shown during my presentation, which I swear to not to do it henceforth. Today also you will see that we don't have Varun, who due to personal reasons could not attend. We hope that he comes in the next video. So, and more so, we had even many more criticisms as to how the analysis can be sharpened, how the views can be expressed clearly, and how much is it important to look into the eyes of the viewers rather than looking here there that what I did in my last video, which I also swear that I will not do. So today the speaker of the day is Siva Mahadevan, who will speak on 65B of the Indian Evidence Act, which is indeed an interesting section, and I hope it is an enriching experience for all of us. I hand over to Siva Mahadevan.
Thank you, Tamogna, and I would like to invite Ishwar as well and welcome him to our group and thank him for the initial idea. So, like he said, I'll be talking about Section 65B of the Evidence Act. So, this is actually one of the more recent and prominent sections of law because during this pandemic time, the relevance of it has increased, and especially after the Arjun Pandit Rao Kotkar case in the Supreme Court on 14th of July, the section itself has been termed as a separate act, and it has been lauded by many to be very like revolutionizing the law in itself, because evidences before were only supposed to be hard copies and before the court, but now due to the situation here, we are changing the ways we see evidences, and now we are also accepting other forms of evidences, and section 65B stands as a pillar towards this change. So before I go into the judgments, which is actually the most important part of this section, it is important for us to understand what the section in itself is saying. So I'll be now reading. So like Tamogna before said, going here and there with your eyesight is not an advisable thing, but I couldn't remember the entire thing, so I have to read. So I'll be reading now. So what basically section 65B is saying is the admissibility of electronic records. So before we go into this, we need to understand two other aspects mentioned in the Evidence Act. One is the primary evidence and the second one is the secondary evidence. So primary evidence is given in section 62. Now what primary evidence basically is the original evidence that can be given. So in case you have the original document, you can give it before the court without the requirements of section 65B. I'll go more into detail about this later on when we deal with the judgments. So an example for a primary evidence could be a laptop which is being produced before the court by the owner of the laptop himself. So in this case, it is the primary evidence as it is the original evidence. Secondary evidence is basically copies of the original evidence. It can be documents which are being copied from the original. It can be the oral accounts of the original, like tape conversations, which are being copied into another hard disk, and then that is being submitted before the court. So section 65B will only deal with the secondary evidence part. When it comes to primary evidence, its relevance is not going to be there, and it in itself will not be applicable towards section 62, which is the primary evidence. So I'll now just read what section 65B says. So subclause 1 says, notwithstanding anything contained in this act. This term is very important to this section, notwithstanding anything. This is actually very important because the main issue in several judgments that we are going to see will be on this two words. That's how important these two words are. So, notwithstanding anything contained in this act, any information contained in an electronic record, which is on a paper, printed on a paper, stored, recorded, or copied in optical and magnetic media produced by a computer. So, this is actually the definition of computer, which is mentioned in section 2, subclause 1, if I'm not mistaken, in the IT Act of 2000, which itself is the basis for section 65, because after the IT Act came, several other changes had to be made towards the other prominent laws, like the Evidence Act itself. So, what basically this particular portion of the Act section says? So, what is notwithstanding anything? Notwithstanding anything can refer to a non-obstant clause. So, what a non-obstant clause basically is that it is something that will overrule the general provisions of the law. So if there is something which is generally speaking about it, a non-obstant clause will go against it and overrule it and itself become the law. So this aspect is very important, since this aspect is the conflict between the state of NCT Delhi case and the Anwar PV case. So I'll go into detail about the facts of those cases in a minute. And this is what is basically said in subclause 1 of the section, which without further proof of the production of original, the evidence cannot be given, which direct evidence, of course, when primary evidence is there, will be admissible. Subclause 2 is talking about the computer output, where it's saying that the computer output containing the information should be produced during a period which the computer was regularly used. So in any secondary evidences, of course, you need to give the original cannot be produced. So it should be proven that wherever the evidence is stored or wherever it was copied from, that particular device, in this case that is defined as a computer, should be in regular use. Because, for example, some persons might do, what they will do is, they'll just go and paste it there and say that it is from this computer. So it is an evidence. That will not be accepted as per section 65B. The timestamp, when you see a file format, there'll be a time when last modified. There'll be a column which says last modified. So that column is important, and that column will show what all time it has been modified. So the timestamp there is what is referred to here in subclause 2. So the computer output should be in regular use, and during the set period when the regular use of the computer is disputed, the information contained in there should be regularly fed into the computer. So again, it is reference to the timestamp. So whenever you type something in, it will show what, maybe it is possible that you can't derive what you typed exactly, that cannot be shown, but when you did that, will show that it was in regular use. And throughout the material, the computer was operating properly. So in case, let us say that the computer which is in question got repaired, or a certain blue screen death happened to the computer and it has to be taken to the store where it has to be repaired. That period should also be produced and shown that during this particular period, when in dispute, the computer was not working, and when it was not working, another subsequent computer was used to store that evidence, and in the end, it was being compiled. So in the end, it was being compiled, and this is what is produced. So this should be shown. And the information content should be reproduced or derived from the information fed in the computer, which is what subclause 2, subclause D says, which is just an additional point to whatever is said before in the other 3 subclauses. Now, if we take a look at subclause 4, this is in direct relation to subclause 2. So what subclause 4 is saying is that any proceedings where such an evidence is going to be produced, in that case, we need to give a certificate. So just because you're claiming so and you're giving these documents doesn't mean that you can just directly come and give them. It is imperative that you have a certificate which says, of course, the certificate is going to be given by an expert. So this expert opinion is given in section 45A of Evidence Act, which also is in correspondence with the IT Act of 2000, which I previously mentioned. It is an amendment clause. So where 45A says that the opinion of the examiner of electronic evidence will be acceptable when the electronic evidence in itself is accepted. So, and again, section 22A will also be applicable here when oral admission to contents of records are relevant. So, section 65B subclause 4 asks for a certificate which will attest the evidence that is being given. So what it will do, it will be identifying the electronic record containing the statement which says that how it was produced. The expert opinion given by the expert here will say what all was examined during, how he arrived at the conclusion that this is a valid document or an invalid document, and he will say what are the devices involved here. So for example, like if there is one computer, it's fine. If there is 2 or 3 more computers, for example, when you go to a company, in company issues, there'll be a network of computers in which it could be simultaneously stored in a cloud. So in that case, he will be giving an attestation as to whether it is being used in several devices or not. And finally, it will be dealing with the matters to which in conditions mentioned in subsection 2. And the responsible official will be signing it. So the authority will be attesting with the signature. So these are some of the important facts given in section 65B. So the first case that is pertaining to section 65B is the state NCT of Delhi, National Capital Territory of Delhi versus Navjot Sandhu and alias Afsus Guru. So this is a 2005 case where I'll be only dealing with the operative part of what the judgments, of what the judges are interpreting it. So here what the judges are saying is that section 63 is talking about secondary evidence, and section 65 of the Evidence Act is talking about the attestations required to produce the secondary evidence. So cases in which secondary evidence related to documents can be given. So here what is said is that in case of electronic evidences, it is not mandatory to follow the rules given by section 65B. What they are saying is section 63 and 65 are there, and it is not like absolutely necessary to follow the conditions mentioned in 65B. In case there is no possible way to get a certificate, for example, in that case it is not required so, and you can just use the other sections of law. So what they are saying is section 65 is a special provision. It is not exactly the main provision. It is only an additional provision, and it does not need to be directly or strictly followed. Here the judges missed the non-obstant clause which I mentioned earlier. The special provision will have more relevance to the general provision. So then the question might be asked if all the amendments, basically amendments are made to give additional meaning in general, is what one contention was given in the case, and whether it can become a special provision. Of course not, because if you take article 21 and article 21A, it is this article 21A is not a non-obstant clause here because it is only an additional thing. Right to education is part of right to life, but it is specifically mentioning it. It is not impliedly mentioned as other rights like environment, if you can take it in that way. So this is what is held in state NCT of Delhi versus Navjot Sandhu alias. Now the next case which we should see is the 2014 case of Anwar PV versus PK Bashir. So this is a very important judgment, since this judgment is concurred with the recent case of Arjun Panditrao Kotkar. So what happens in this case is that there is a dispute between two politicians about the election. So what will happen is, here Anwar PV alleges that PK Bashir here has put up several posters, songs, and other forms of evidences, other forms of documentary evidences, or media evidences, or whatever it is, to claim that Anwar PV is corrupt and he has done many mistakes and he is not an eligible character for the election. So what his claim is that all these allegations against Anwar PV, or let's just say it's the petitioner, is not valid, and it was made with a prejudice to ensure that the people will not go and vote for the petitioner, but instead will go and vote for the respondent. So here he is claiming that the respondent intentionally infringed his character before the public, ensure that he gets the election. So this, as per section 100 subclause B of the Representation of People Act, which is read with section 123 subclause 2 of the Representation of People's Act of 1951, is a violation, and therefore the election of the respondent here should not be held valid and instead should be made void. This is the claim made by the petitioner in this case. So that attesting this claim, he is attesting this claim by producing the documents in an electronic form or in a digital form. So now what the judge is going to look at here is, he's starting to look at the necessary sections for this case, which is section 22A, which I already explained, section 45A, section 59 of Evidence Act, which says the proof of facts by oral evidence, section 65A and section 65B. Now, what is the issue here is, has the petitioner here given enough evidence to convince the court that the respondent has intentionally infringed the character of the petitioner? So now the first thing is, they again are going to analyze the state of NCT case, where it is said that it is not necessary to have the necessary conditions prescribed as per section 65B subclause 4 of the act, where the certificate is required. While filing the petition, the petitioner does not give any certificate. He just gives the evidences, and what he is claiming is, as per this case, it is not, it is said that secondary evidences under section 63 and 65 is allowed here, and 65B is itself not mandatory. Now, the important aspect here is whether this claim can be allowed or not, because in essence, the state of NCT of Delhi is a precedent towards the Anwar PV case, and obviously the precedent can be taken upon. However, what the court is saying here is that section 65B is not a general clause, it's a specific clause. As stated by the non-abstinent clause given initially, it will override the general laws which is pertaining to it. Of course, it should be ensured that it doesn't infringe upon any other law mentioned in the Evidence Act itself. But here the whole question is based on the admissibility of electronic evidences, and in that case the important aspects mentioned in section 65B subclause 4 has to be followed strictly. It cannot be deviated. This is what is mentioned in the Anwar PV case. And this thing, they are saying that since the certificate was not produced, the case is not being proved by the petitioner, and the respondent election is not void and it will be valid. So this case is concluded in this way. Now, there is another important case, which is the Tommaso Bruno versus State of UP. This case, even though doesn't mention section 65B in depth, is very important because the facts in relation to section 65B will be dealt in the Arjun Pandit Rao case, which came very recently. So what will happen in the Tommaso Bruno case is that there will be 3 foreigners. They will come to have a tourism tour of India. They are coming to, I think they're coming to Varanasi, and they are taking a room at one hotel, Buddha. And Tommaso Bruno and there's the second appellant of this case, they are alleged to have killed the third person traveling with them. How are they alleging this is, on one particular day, the Tommaso Bruno and the second appellant are saying to the waiter or the room boy that they don't want to be disturbed till the morning. First point. The next thing is, then next day at 8 a.m., Tommaso Bruno and the second appellant are claiming that the third person with them is gravely ill and they need to take him to the hospital. So they're taking him to the hospital, and on reaching the hospital, the doctor is saying that he is dead, he is brought dead. While they are doing the autopsy report, the reason for death is strangulation. Okay, so with this, they are asking the roommates, because the time of death is between the time in the night and 8 a.m. They are asking the roommates, where were you? So they are saying that they had gone to see one place a tourist place at 4 a.m. and they came back at 8 a.m. Now, as per the Evidence Act, there are certain conditions to the alibi, and these conditions are not met by them because they are unable to prove their alibi. Okay, and Evidence Act is saying that it is upon the accused to prove their alibi. The onus of the burden of proof is upon the accused. This is the argument, and they are now saying that since they couldn't prove this, and since all the circumstantial evidence is pointing towards them, these people are guilty and they are arrested. So in the trial court says that they are guilty and they are convicted to life because again the two accused here are basically claiming the same thing. They went to visit the tourist site at 4 a.m. and they came back at 8 a.m. When they came back, this person was gravely ill. So they called the bus boy there and they asked him to call an ambulance. The ambulance came, and when they took to the hospital, he was mentioned brought in. We don't know anything apart from that. They're not saying anything apart from this. The second thing is the other apparently what is that there is evidence produced by a witness, which I think is the cook or the waiter there. He's saying that basically the two accused here were in a romantic relationship, and while they are happily there, the deceased here is being depressed. So basically they are imagining a scenario where there is a love triangle here, and because of that there has been some friction there, and because of that he was killed. Okay, so with this they go and arrest him, they put him, and the High Court also accepts this view. What the Supreme Court here is saying is that the hotel is in a tourist spot, so CCTV cameras are there. No CCTV camera was brought forth to them. The evidence in the CCTV camera was not brought forth to them. The thing is, the appellants in the case are also not claiming to a CCTV camera footage. Without the documentary evidence or the electronic evidence here, which is much more reliable than whatever the interpretation done by the police or the prosecution side, and merely with the statements of these of the waiters or the cook here, who is just assuming that because he is depressed and because these two are seemingly to have a love affair, then this is what's going to happen. He's just interpreting in his own way that since these two guys are happy, and since that the deceased is depressed, so there's a friction between them, and because of that they killed him. And because there is no way to prove by the accused that they were at the tourist site, they didn't go there, they are lying, and they're just interpreting and they're just inferring this from very basic facts. So what the court says here is, as per section 65B, you can bring forth the evidence, the CCTV camera footage, which is not going to be the original evidence because they're not bringing the camera itself. They're only going to copy the evidence from the camera, so they have to attest that with the certificate. This was not done by the prosecution. So without this evidence and with very fragile circumstantial evidence, there is no way to convict him. Another thing is, it is not required for them to request such a certificate in case it is not obtainable. There can be some extreme scenarios where they cannot obtain the evidence, where they cannot obtain the certificate from the respective officer. In that case, such a certificate is not required, but they got brought before the CCTV evidence anyway. And this court will have the discretion to analyze that as per section 136 of the Evidence Act, where the judge is given the power of discretion to decide whether such an evidence is acceptable before the court or not. Without that evidence, there is no way to ascertain if the accused were actually there in the tourist spot or in the room. If that evidence was brought with the certificate and the video proves that they did not leave at 4 a.m., they did not go to the tourist site at 4 a.m. and only came back at 8 a.m., their conviction would be proved beyond any reasonable doubt. But without that evidence, there is no way to decide if it is even possible that the accused were not there at the tourist site and in the room and they actually killed him. Strangulation is the cause of death, but that doesn't necessarily mean that these people have strangled him to death. So with this reasoning, the court said that the accused were not proved guilty beyond any reasonable doubt and they were acquitted. Here, the case in itself, even though it's very interesting, is not actually relevant to the section here. The point is, the court said that if it is not possible to gain the certificate before an appropriate time, it is okay. We can accept that and the discretion can be used and you can still produce it. Now, what is happening in the Arjun Pandit Rao case. Here, again, there is an election dispute, but here the dispute is not because of the result. It is because of the filing of the nomination filing. So what happens here is the respondent, the petitioner here will file the petition like 54 minutes later than the deadline. So the deadline will be at 3 p.m. He has to file it before 3 p.m. and 54 minutes later only he will go and file it. So what the respondent is doing, he is filing a petition before the court saying that he has not filed it in the proper time. So he cannot possibly even contend in the election. So there itself a mistake has been made. Now they bring in a witness, the officer who was there receiving the nomination. The officer there is saying that no, he did not file at the proper time. He came late and only then he filed. This oral evidence, as per the Evidence Act, we saw that an oral evidence as per 45A has to be attested only if the relevant documents are given. So what now the respondent is doing is, he is asking for a certificate from the election authorities because there is a CCTV camera in the place where he will go and file a nomination. So he is asking, please give me the video reference and give me the certificate saying that this person did not come there in time to file the nomination. They are not giving it. So they are repeatedly asking, they are not giving it. So what the respondent is doing is, he is going to the Chief Election Commission and he is giving there a petition saying that he is requesting the certificate. The certificate is not being given as per section 65B. Now, there was no reply. Here at least they are saying that due to some reasons we couldn't do it. The reasons are very petty and they're not really, reasonable reasons. They're just saying that we couldn't give it, the officer is not there, whatever it is. We don't know the exact reason, but they're giving some excuse basically. But in the Chief Election Commission, no reason was given as to why he is not giving the certificate. Due to this, he is filing a case. The respondent is filing the case, and both the trial court and the High Court finds that because there is no other additional evidence and the certificate is not given, the witness statement given by the nomination officer, the person who is receiving the nomination, will itself be considered as an expert witness because there is no other witness or evidence to prove that he has come at the right time. So the nomination was filed late and his nomination itself will be void. Now he is coming to the Supreme Court. The petitioner is appealing before the Supreme Court. His claim is that it is not his reasoning to why the certificate was not given. There is no proof that he actually came here late. Because there is no certificate and there is no evidence to say that he was late, there is no way that the court can reason that way. Now, he is referring to the Tommaso Bruno case. Okay. Here, the court is also saying the same thing. Justice Nariman, what he said is, yes, it is true that in case of some really emergency situation or where it is impossible to receive the certificate, yes, an evidence given based without the certificate as mandated by section 65B subclause 4 can be accepted. But the difference between what happened in the Tommaso Bruno case and here is that in this case, the respondent has repeatedly asked for the certificate. There, the certificate was not asked for at all, either by the prosecution or by the defense, or in the correct terms with the petitioner and the respondent. Both of them did not ask for the certificate. Here, on the other hand, the respondent is consistently asking for the certificate. He has gone to the High Court, he's gone to the local election office, he's gone to the Chief Election Commission, he's gone everywhere where he can get the certificate. Still, the certificate is not given to him. However, in the Tommaso Bruno case, there is no certificate was requested. With this fact, if you see, Tommaso Bruno case is saying that in case you cannot receive the certificate, you don't need to give it. But the point here that is mentioned by Justice Nariman is that if you are not even asking for the certificate, then the certificate cannot be rejected as a whole. You are not even asking for it and you are saying some excuse for it, that won't be accepted. That point in law mentioned in Tommaso Bruno case is not valid. In this case, the respondent here is asking for the certificate again and again. It is not given to him on basic reason. Respondent here is not responsible to produce the certificate. The authorities are the people who need to give the certificate. It is their duty to produce a certificate on a request. They have to see the video evidences. They have to see what exactly happened. They have to see if the claim is that, and they have to certify how they came to the conclusion, all which is mandated by section 65B subclause 4. However, in this case, none of that is done. Even though he is asked, it is not given. So what Justice Nariman is saying that it is not the duty of the party who is claiming the certificate to produce the certificate. If his duty or responsibility ends with the place wherever he is claiming for it, all he has to do is go and file before the appropriate authorities that he wants the certificate. That is only his responsibility. Apart from that, it is not his responsibility. It is the responsibility of the authorities to give him the certificate. Okay, it is not his duty to go on and nagging them for the certificate. It is not his duty. So with this reasoning, they are saying that since the certificate is not given and since there is no other evidence here, the evidence given by the nomination authority will be accepted and the election held there or the nomination given there is void. So this is exactly what happened in the Arjun Pandit Rao case. So why is this case so relevant? Is because this case has not only affirmed the Anwar PV case, it has also given several other aspects to it. Like Section 65B mandates it, but this case now is giving the exceptions towards it. 65B is actually acting as to what needs to be done to produce the evidence, but it is not talking about its relevancy. So just because you are following all the things here, whether the evidence or not will be relevant or not is not being talked at all in the section. So this is an aspect which is being talked by Justice Ramar Subramaniam in the other part of the judgment, where he is going on to explain what exactly the section is. He's not talking about the case in it. He's just talking about the explanation of it. So this is why this case is being very important, and it is said as it is affirming basically what is said in Anwar PV's case and saying that it is true that Section 65B and A are an act of its own, and they are not just the additional provision. They are a very specific provision which, as mentioned in the non-obstant clause, will overrule the general provisions. So this is basically what is said, and of course they are going against the judgment here. It is the Shafi Mohammed judgment, I think, where it was said in that judgment that judgment is referring to the Tommaso Bruno case and the state NCT of Delhi case, where the Tommaso Bruno case is actually not referring to the Anwar PV case. It is referring to the state of NCT Delhi case, which is actually being overruled by the Anwar PV case. So by the reference itself, the case is wrong. So with this reference, the Shafi Mohammed case, where it is said that, again, it is just basically saying what the NCT Delhi case is saying, that it is not mandatory to produce the certificate as per Section 65 subclause 4 is overruled. So the judgments of state of NCT Delhi, Tommaso Bruno, and the Shafi Mohammed case, these three are overruled, and the Anwar PV case is upheld again in this case, in the Arjun Pandit Rao Kotkar case. So this is basically a brief summary of what Section 65B is. Of course, there are several other aspects to it which I didn't talk about, like in Justice Ramar Subramaniam's judgment, he is talking about the other country aspects, like what is mentioned in Canada, how they have brought into the electronic evidences, how they are handling it. And even in Justice Nariman's judgment, he is also mentioning the UK Civil Code, where it is actually Section 6 subclause 1 is the direct inference for 65B. That is what is mentioned. I have not gone into that, but this is just a brief idea of what Section 65B can be. Thank you.
It was very interesting interaction in this. I have just one question. So consider for a minute that there is no original. That the CCTV was taken, but there is the CCTV itself is not there, but the recording is there. For that, will 65B certificate be required?
Yes, because for any primary evidence or original evidence, 65B will not be applied. But for any other evidence, records or something, you have to get a certificate, because there is no way to convincingly prove that it is a valid document. If it is an original document, then it can be given without the need for any attestation. But for any other copies made apart from the original, you have to give a certificate as per 65B subclause 4. That is mandatory. That is what is upheld here. It was not said mandatory in the other three cases I mentioned, like the NCT Delhi case, Tomaso Bruno case, and in the Shafi Mohammed case. But in Anwar PV, which is upheld here, and the Arjun Panitra case, it is said it is mandatory. And in the Arjun Panitra case, the exception is given if it is requested and the certificate is not given within the time limit where it is not going to prejudice the accused in case of a criminal case or the other party in a civil case, then you can use the exception and accept that case using 136.
Thank you.
I would like to first congratulate you for an amazing presentation, and would like to ask you a simple question. Can an audio recording, which is recorded without the consent of the respective person, be used as an evidence in a court of law?
Yes, this is actually mentioned in one case which I saw, but it is usable in case it's a original recording. So I actually think I remember that case now. It is 1 minute. Let me just yes, it is Vikram Singh versus State of Punjab. In this case, what will happen is the appellant here is accused of criminal conspiracy, murder, and several other things on the basis of a tape recording. So here the tape recording is taken without the consent of the accused, obviously. So the tape recording is an original document. Okay, in case it's an original document, you don't need to attest it also. In case it's a secondary evidence, then the evidence should be proven as per section 65B. So this aspect is actually taken into account. Even in Justice Nariman's judgment, he will mention a point where the Chief Justices of India created a community which is going to be headed by the Chief Justice of Punjab and Haryana. He will create certain rules, a draft of rules, which will include all these rules to how we can produce evidences on tape recordings also. That is one aspect there. So yes, tape recordings can be accepted as evidence, even if it is without the consent of the other party.
Okay.
So, any other questions?
I'm done.
All right. So, if you guys got any understanding of this, you can summarize it if you want. Because I think I was like going here and there, but okay, whatever.
It was quite a holistic approach because from where you discussed from the very beginning, you discussed how because a law is the tests in the test of time with the evolution it gets to its judgment. You discussed the 2005 judgment where it is said the 2005 the state of NCT Delhi versus Navjot Sahu, where it was held that section 63 and 65 is important are an important facet. Then you went to the Anwar PV's judgment where you talked about 65B. Then you went to the criminal case, which even though is fascinating, but still as it is not related to that much with the section at hand, but still the way it has looked into a CCTV footage and how it can be brought before a court is really exceptional. Then you gave a reference about the Shafi Mohammed judgment of the Supreme Court of India, where if certificate not available, then documents can be accepted only in criminal cases. That was one of its main agendas. Then you went to the very recent Arjun Pandit Rao Kotkar judgment, which I believe is even though it has very minutely touched upon the section, but as it is a very new development, it will act as a precedent for life till a new judgment comes. So it was. I don't know whether I have justified your presentation, but still it was an amazing presentation, and I believe that the viewers will be enlightened more in this subject matter.
Thank you. And of course, there is another interesting aspect. Like I think in Shafi Mohammed, it was a 2-bench judgment, but they went against the 3-bench judgment given in Anwar PV's case. So that is also an interesting aspect, which was also mentioned. It's mentioned as an obiter dicta in the judgment, in the Arjun Pandit Rao Kotkar judgment. Yeah. So even though like there are each case can be dealt in huge depth, you know, each case has its own facts and circumstances which are very important. But as this is only going to be a general brief about the evolution of this section, I just thought of dealing with the two important cases just relevant today in detail, and the others in just a side note. Of course, if we can do another one on section 65B, I can try to read and explain the other judgments also. So, yeah.
I believe the holistic approach has been the law at large has been set to the explanation as such has been set to motion. So now let the viewers be enriched with the curiosity to know that they will go on to other judgments if they feel.
Yeah, I actually request everyone to give some criticism because I'm quite sure there will be a lot, and I want to learn more about this. It's a very new provision, and the another key question should be like if it can be made in a more permanent basis, like with the current scenario, electronic evidences, the importance of it has increased a lot, and if it is made in a permanent way, now of course it is also environmentally good. You know, you don't need to take a lot of papers for it. So many trees are cut down, and the courts are also using several papers. Even the Supreme Court has said that we're going to reduce the amount of papers we're using. A4 sheets are going to be preferred, all this. So if electronic evidences are made a more permanent thing, then the need for the papers itself will be reduced, and everything will become digital. And that is like the next step for judiciary on a whole, as far as my opinion is going. So if that is a possibility or not is it's a it's a deep question which only time will answer, but your opinion on that will of course be welcomed.
No, even Justice Chandrachud, I think in his E committee as he's the chair, it, he has given a view on the fact that because now at least in the district courts also through WhatsApp and through other means you can send summons. So if that can be done, then I believe that electronic evidence can also be served. But electronic evidence can also be given. So so if because as more digital we will be, then it will be better for the litigant as well as for the lawyers to get an easy access to is not easy access but the justice to be done in a very swift manner than to go through a uh, barrage of witnesses to attest or to corroborate such an evidence. So I believe that.
Yeah. So is there anything else you guys would like to ask me? Final
No.
remarks, anything?
With the limitation of judgments and the limitation of about the understanding of law at large through journal readings and others, is we are in limitation to ask questions. We are under
Okay,
it.
yeah. So let's receive questions from the viewers, and of course it will be a learning experience for all of us. And I thank everyone, the viewers, and of course Tamong Danish for giving me this opportunity. And it's actually quite late here, so thank you for staying awake for such a long time. And uh, we'll see you in the next video, which I think Ishwar will be doing. If he decides his topic and says we'll do it on that. So thank you, and see you next time.